very good afternoon to one and all present here. Uh, my name is Monica Ruby, and I'm from the Department of Management Studies BBA from Women's Christian College. Today I'll be taking a session on the legal aspects of business, which also talks about specifically the contracts. So before getting on to the topic, um, what is legal aspects uh, of business, and why do we actually study the legal aspects of business in terms of in terms of management is because whenever a lot of us get into entrepreneurship and we want to start our own business, either it can be a sole proprietorship or it can be a partnership, or it can be a public limited or a private limited company. So we have most of us have, the we have an interest towards entrepreneurship. So when we actually get into starting an organization and stuff, we need to have a basic idea of the legal system of our Indian legal system and how it works, and what are the clauses and what are the constraints and what are the formalities. And also, this is one necessity or a need of studying legal aspects of business. And one more important aspect is, we shouldn't get fooled by someone else who gives us false information, or one important clause of legal aspects of business is, ignorance is not an excuse. So you need to be aware of the legal system. You need to be aware of the laws that govern our business transactions. So basically, we are studying about all the predominant laws that govern business transactions, and how the students will get benefited is these two ways. If they're going to start up their own firm, as in if they're going to become entrepreneurs, then it will help them to with regard to the legal formalities that has to be complied with. And secondly, it will give them an idea of how to be um, prudent and vigilant about information, and not unnecessarily get into trouble or unnecessarily get into a contract or a legal relationship with someone, which will end up becoming a huge loss for them. Okay, so the first important aspect under legal aspects of business is the contracts, which is also the Indian Contract Act. So before we get on to what is an Indian contract, we'll just see the basic important elements of what's a contract and what are the essential elements of a valid contract. So, when you see the law of contract, it's actually a civil law. It's more of a civil law, and it governs majorly business transactions. So it's a branch of law that determines the circumstances in which promises made by the parties to a contract shall be legally binding on them. You have to get into a contractual relationship with another person, where you get into an agreement with another person, which is legally enforceable and legally binding. So a contract is an agreement that's made between two parties, which the law will enforce. You cannot enter into a contract on a specific thing which is unenforceable, which is not valid, or which will go against our legal system. It has to be abiding by our legal system. It should be enforceable. So a contract, in short, is an agreement that is enforceable by law. And every agreement, if you see, is a promise or a set of promise forming consideration for each other. Suppose if there are two entities in a contract, and there is a business transaction. Suppose there is a person who's willing to sell, let's say, 100 cartons of oil to another person in exchange of money. So whatever the person gets in exchange here is the consideration. And whatever agreement they come across, where I will sell you 100 cartons of milk and you have to pay me this much amount of money. So this is a set of promise. it can be one promise, it can be a set of promise, or agreeing to supply milk for a period of 1 month, or however the contract is framed between the two people with the consent of both the parties. So an agreement is a promise or a set of promise that forms consideration for each other. And a promise is an accepted proposal. So suppose if I am willing to sell 100 cartons of milk, I am coming up with a proposal that I have 100 cartons of milk and I'm willing to sell it. And so I am offering it, so and someone has to accept my proposal, whatever proposal I'm offering. Another person has to willingly, without any force, accept my proposal. In that case, it becomes a promise. A promise and a set of promises becomes an agreement, and an agreement that is enforceable by law is a contract. Majorly, contracts are, if you see, the nature of contracts is majorly governing business transactions. So you have contracts that govern different kind of transactions, like selling of goods and services, or having a principal and an agent relationship, a guarantee and an indemnity, mostly in business or mercantile transactions. So, but a small element of contracts are also they're also called as agreements that are opposed to public policy, where we talk about contracts that is immoral, and it's kind of it is detrimental to the society. So those kind of contracts are also is something that is covered under the legal aspects of business as a subject. So before agreement, there should be consensus addendum, which means that the parties should agree to the subject matter of the agreement in the same sense at the same time. So we have a set of requirements or essentials of a valid contract, which has to be fulfilled for the contract to be enforceable. If any one of the requirements is not fulfilled, then it cannot be considered as a valid contract, and eventually it will become void or unenforceable. So consensus addendum is one of those criterias. Consensus addendum actually speaks about how uh, both the parties to a contract should agree to the contract terms and conditions. They should have understood it in the right manner. They should have agreed to it without any, miscommunication, or without any manipulative information. Okay, so they should have willingly accepted, and they should have agreed and accepted to the subject matter of the contract. For instance, what we say is subject matter of the agreement is, suppose, even in the example that I was talking about, milk. I can sell. There are different kinds of milk. I can sell a cow's milk, or I can sell. You also have people following vegan diets now, where they speak about plant plant substitutes. So you have soya milk, almond milk, all that. So I'd have to specify what sort of milk I am selling. Suppose if I'm willing to sell 100 cartons of cow's milk, and the other person is actually thinking it's going to be 100 cartons of almond milk, then there is no consensus. So obviously he has actually assumed it to be almond milk, but I've assumed it, but I'm going to give a cow's milk. So the subject matter is different. So the contract might become void. So this is what consensus addendum is about, where we actually agree to the contract in the same sense, in the same manner, understanding it in the proper way. Okay. So some of the essential elements of a valid contract, some 9 important elements are there, which has to be fulfilled for a contract to be enforceable. First is offer and acceptance. There has to be an offer or a proposal. Okay, somebody cannot come and force me to sell something, or I should be willingly ready to offer, even in this case the milk, and the other person should also be willingly accepting, without any force, or without any other clauses, or without any other interventions. He should be ready to accept. Someone else should not tell him to accept. So there has to be a proper offer and acceptance in terms of the contract. Secondly, very important, there has to be an intention to create legal relationship. You need to have an intention to create a proper legal relationship. You cannot enter into a contract which is illegal or unlawful. There are two different kinds of contracts. You have illegal contracts and then you have unlawful contracts. Unlawful contracts are those kind of contracts which are unenforceable. You cannot actually fulfill it. It's not possible. It is not physically possible, or it is not legally possible. For instance, selling or buying of your pistols, or all those machinery that's used in defense. You need to have a license. You need to have, even to own a pistol, you need to have a license. So you cannot buy or sell those, without having the right permission or the license and all that. So those are all something that is unlawful. Illegal is something that is immoral. Immoral, as in, giving money to someone to get divorced, or getting the consent of the parent to marry a minor girl, um, without her own permission. So that is, those are all contracts that are immoral. So in a way, they are illegal. So you have illegal contracts and then you have unlawful contracts. Both do not have an intention to create legal relationship. So eventually, both will become void contracts or unenforceable contracts. There has to be an intention to create a legal relationship. Thirdly, there has to be a lawful consideration. The consideration is what you get in return. Okay, quid pro, you actually say it in Latin. So it actually says that, suppose if I'm giving you a product, what do I get in return? That is a consideration. Every contract, every business contract must have a consideration, which means that there has to be a price. What you get in return, it can be a barter system, that you give one good and you get another good in return, or it can be money. Okay, but there are certain exceptions where consideration need not be there and still is considered to be a valid contract. For instance, you can get, your father buys you a house or a vehicle, and then you don't actually pay him back because it's done out of pure love and affection. So in that case, there is no consideration in the contract, but yet it is completely lawful. So there are certain exceptions in every all these criterias. Nextly is capacity of the parties. What is the competency of the parties? Both the parties entering into a contract should be competent to enter into a contract. Competency is actually determined on three major levels. One is, the person entering into a contract has to be a major. Okay, he has to be predominantly a major who's entering into a contract. A person who is a major means he has to be 18 years old and above. Any person entering into a contract lesser than 18 years is not, is not valid. So a person has to be a major. A person has to be in a sound state of mind. You cannot enter into a contract with a person who has either in a state of drunkenness, or who's incompetent mentally to enter into a contract, who doesn't have the basic understanding or the basic IQ level of what is right or what is wrong, or who is, normally we call them mentally retarded, but retarded is considered to be an abusive term. So you we normally say it as mentally incapable to enter into a contract, who doesn't have the power to discern what is right and what is wrong. So that is one criteria under competent to enter into a contract. So you need to have a person who's a major, you need to have a person who is of sound mind, and thirdly, he should not be acquitted by the law. He should not be a convict acquitted by the law, either for simple crimes, or if even if he has committed any crimes or any offenses according to the IPC or the Indian Penal Code. He cannot enter into a contract. But if a person is on parole, suppose a person is in jail for some crime and then he comes out on parole for like 15 days or 20 days. During that 15 days or 20 days, he can enter into a contract. So there are certain exceptions here and there. Okay, so competency, we saw three things. One is, a person should be a major. Secondly, he should be a person of sound mind, and thirdly, he should not be acquitted by law. And the next one is free and genuine consent. A person should be um, able to give his consent to a contract, that is willingness, either in terms of offering a contract or in terms of accepting a contract. There has to be free and genuine consent. I am intentionally, with the right intention, with the true intention, wanting to enter into a contract. So you cannot force me. Again, there are four different clauses here. You cannot pull someone into a contract by coercion or force. It can be physical, mental, sexual, different kind of coercions. Secondly, I cannot exhibit undue influence because of my position. Okay, for instance, if there is a doctor who is the only specialist for a particular operation and then he charges a very high amount, then it's not a case of free and genuine consent, because the other person is kind of, in a way, forced to, you know, enter into the contract because he has no other option. And the doctor is making undue, he's like having an undue advantage because of his position. So that is one clause under free and genuine consent. And then, it both should have understood the contract in the right way when I spoke about the subject matter. So it shouldn't be a mistake, and there shouldn't be any fraud or misrepresentation. Intentionally, you cannot use manipulative statements to deceive the other person. And secondly, you cannot, even unintentionally, you shouldn't do. Even if you do it unintentionally, it's still considered to be a void contract. But yes, you can probably, there are certain elements of the contract which can proceed if it's a misrepresentation where it was done unintentionally. But certain statements which gives a wrong meaning, if it was done intentionally to deceive the other person, then the contract will eventually become a void contract. Then the contract has to have a lawful object. The objective of the contract should be lawful. It shouldn't be illegal or immoral. And the agreement should not be declared void. It has to be legally possible and physically possible. It has to have certainty and possibility of performance. There has to be possibility. It should be possible to perform. And every contract, in terms of every business, has certain legal formalities that has to be, uh, that has to be uh, taken care of. For instance, if you're actually buying a land, you need to have the sale deed, and then on a revenue stamped paper, and then you need to get the signatures of the person who's selling the land. You need some witness signatures. You need the registrar's signature, your ID proofs, and so all these formalities are there, which has to be fulfilled. So every contract which is legally binding has a set of formalities that has to be fulfilled. Even if you're starting a company and then you want to register the company, that is also a contract where you're trying to get into forming a company. And in that case, also there are certain formalities which has to be fulfilled. Okay. So these are some of the essential elements of a valid contract. Even if there are certain exceptions in all these elements, but all these elements are required for a contract to be valid, to be legally enforceable. So this is what contracts about is about. Thank you so much. I will see you in the next lecture.